Mr. Wolfgang?
Thank you, Your Honor. May it please the Court, my name is Kirk Wolfgang, and I represent the appellants in this case. This case is before you because it involves a serious abuse of important rights of the appellants by the government, specifically the Board of Appeals. These appellants are average and not so average Americans. There's a disabled Vietnam War veteran among them. There are people who have devoted their lives and careers to military service. With the exception of one or two of them, their voluntary participation in the Charles County Board of Appeals case, known as docket number 1232, marked their first participation in any such proceeding. They came to the process not knowing what to expect, but hearing from the chairman of the Board of Appeals a typical summary of the rules. I have a few brief statements to make for your edification, he said. The Board of Appeals is a quasi-judicial board appointed by the county commissioners. The board is charged with the responsibility of applying the Charles County ordinance to each application for a variance or special exception in a fair and impartial manner after a hearing where all parties and interested persons are heard. Our decisions, and this is very critical, tonight we are going to have a large audience for at least one of our hearings. Our decisions are not made on the number of witnesses or the quantity of evidence, but rather on the quality of the evidence. Repeating a point of view or an opinion already given does not make it any more credible, and repetition is to be avoided if possible. We request that proper decorum be observed. Do not speak until recognized. A sign-in sheet is located in the back of the room for each scheduled hearing. Only those who have signed in will be allowed to speak. Each member of the Board of Appeals is required by law to be and remain impartial to both sides and can only base his decision on the evidence presented at the hearing. Consequently, any verbal communication with a board member outside of the hearing room pertaining to any pending case is strictly prohibited under the ethics of all independent boards. The board appreciates your anticipated respect for this process. He then goes on to say that the witnesses' speaking time will be limited to 3 minutes. But that's it. That is what they were told to prepare them for this process. There was no announcement that there is a set of rules for the Board of Appeals for them to review. There was no discussion about how to present evidence or that they were entitled by law to cross-examine the witnesses. The attorney for the board summarily then and on his own threw out the emails in opposition to the application that had been received by the board prior to the first night's hearing, without the board members or the chair making any kind of a motion or ruling, and after discussions with the applicant's attorney, but without asking any of the Protestants if they had a comment or objection. Parenthetically, the Board of Appeals has used emails in other proceedings for years. Some of the Protestants asked questions of the witnesses of the applicant during their 3-minute testimony, or directed questions towards those witnesses. But those questions were not answered, and the uninformed citizens did not know that they even had a right to expect answers to those questions. At some point,
counsel, can I interrupt you just?
Yes, sir.
Was there any after that announcement of the procedure? Did any of the Protestants or any counsel for the Protestants stand up and say, you know, Mr. Chair or Madam Chair, I would request the right to cross-examine the applicant's witnesses? I mean, was there ever any request to say that I wanted to cross-examine?
Your Honor, now we come to another sore point in this proceeding, and that is, as you already know, the record of this proceeding is not complete. It is my recollection that in the incomplete portion of this record that there were requests made to ask questions. The term cross-examination was not used, but that there were requests to ask questions of the individuals, and the response from the chair was, you can ask questions during your 3-minute period.
Okay, well then maybe you can kind of complete the visual picture that I'm having some trouble with. Was what happened that the applicant called witnesses, those witnesses, and the applicant's counsel examined the witnesses gave their testimony, and then the witnesses were excused, stepped down from the stand, and it was only when the protestant, their case, that they got up and during the 3-minute asked a question to the air, and nothing came back? Is that what happened?
Exactly, Your Honor. Exactly.
So so during the 3 minutes, somebody said, well, I want this question answered, and no answer happened?
Yes, Your Honor. And in addition to that, you have to keep in mind that the Protestants were testifying on 2 separate nights. The individual witnesses were not there on the second night when some of the Protestants spoke for the first time, and the only time on the second night of testimony.
Were any of those Protestants adjoining property owners to this facility?
Yes, Your Honor.
How many? More than one, or?
There's one that I'm aware of. All were in the vicinity. Almost all were in the vicinity, but there was one that I'm aware of.
And that person testified?
Yes, Your Honor.
Were all of the Protestants as a group represented by an attorney?
No, Your Honor. In fact, the first night of the
is it your position now that as each witness was called by the applicant, that all of the various Protestants should have had an opportunity, one after another, to engage in cross-examination?
Precisely as the Board of Appeals rules of procedure says.
Does that mean yes?
Yes, Your Honor.
Right.
And that is as it is stated in the Board of Appeals rules, that there will be, that the order of proceeding will be opening arguments, and then the applicant puts on a witness, the witness is examined, then cross-examined, then redirect examined.
And it could have been serially by 30 different Protestants.
That's correct, Your Honor.
30 different cross-examinations.
That's correct, Your Honor. And whether the rules are a wise idea or not is another story, but the rules are the rules, and that's what the rules say. The rules actually call for recross examination as well.
But was there a videotape or an oral tape made of this hearing?
Yes, Your Honor.
And you're saying that was only partially transcribed?
Yes, Your Honor. Apparently, I'm not certain what the problem is with the transcription, but as in other forums, they use a certain tape recorder as the official recording transcript, but they also have audio-visual equipment to broadcast these things. Apparently, the official...
One other thing I'm not quite sure of. I gather this 3-minute limitation thing came up. The applicants had finished their case, and the Protestants are putting their case on as they call the Protestants one by one.
That's correct, Your Honor. However...
But then is each Protestant saying, I want to recall one of last night's witnesses so I can cross-examine?
No, Your Honor. There was no such statement made.
Well, then, as Judge Woodward said earlier, to whom these questions directed? To the air?
We're talking about people who were unrepresented. I represented no one until the second night of the proceedings, and they had no idea how to proceed. They had the board chair tell them, you can ask the questions during your 3 minutes, and that's what they did. There was no answer to their questions, but their questions were asked. May I proceed?
Sure.
Oh, I should say one other thing, Your Honor. The statement having to do with the 3-minute limitation was made at the beginning of all proceedings, and the limitation did not apply to the applicant's witnesses, only to the opposition witnesses.
Can you tell from the transcript or from anything in the record, I guess is the best way to phrase it, how long each of the applicant's witnesses actually testified?
I should have made an attempt to make a timing of them. If I could estimate, I would say that the longest witness was probably 20 minutes, 25 minutes, something in that order.
Did any of the protestants make a proffer that within the 3-minute limited period there were a fourth or fifth or sixth question they didn't get an opportunity to ask?
There were two witnesses who did not finish their questioning that it was obvious from watching the videotape that they were not finished and did not want to stop their questioning, but they were dismissed. After the close of all of the testimony, the board chairman closed the record, but announced that the board would visit the property. He decided that not everyone could attend the visitation of the property, but allowed the one opposition attorney to go and one other opposition party chosen by non-scientific means from the audience. I was the sole opposition attorney, and I was brought into the case after the first night of testimony. And I started my research by looking at Article 66B regarding boards of appeal. There I learned that the board must have a set of rules. 66B Section 407 requires that each board make and keep rules. I went to the county law library to find the rules for the Board of Appeals. There were none there. I checked the circuit judge's chambers, no rules. None on the county website, none at the public library. When I called the assistant county attorney and asked for a copy of the rules, he told me that I should look at the county ordinances. I had looked. While there were ordinances, there were no rules. Then he remembered that he carried something about the conduct of the meeting in his briefcase. He offered to copy it for me. On the day of the site visit, which was March 17, 2009, he gave me a copy of the Rules of Procedure for the Board of Appeals, which I in turn shared with the other Protestants. For the first time, the Protestants became aware that they had been denied their right to cross-examination of witnesses. Not only denied cross-examination, but denied recross-examination. And anyway, how was that cross-examination to have been possible within their allotted 3-minute time? The site visit that occurred on March the 17th excluded some interested persons and also property abutters who tried, in fact, to join the group. During that meeting, the attorney for the applicant made a 20-minute presentation to the board. He showed a designer schematic of the proposed facilities and presented a copy of a document regarding an ancient special exception that was purportedly granted on the property for an air park in 1960. He specifically did not offer it as evidence, but it was reviewed by all board members.
Counsel, let me just stop you right there. Was there any recording device? Was there any recording of the site visit and who said what to whom during that site visit?
No, Your Honor. There were some people taking notes, but as the site visit progressed, the entire group, including the group of the Board of Appeals, did not stay together. And so there was large portions of this site visit in which there were no notes taken of what was being said.
Was there any minutes that were prepared by any secretary to the board or any administrative assistant to the board that were then subsequently presented and adopted by the board?
If there were, I am not aware of them. It is not part of the record that the board produced for this proceeding, Your Honor. And I suspect that there was no such record.
Was there public notice given to the of this site visit under the open meetings law?
The only public notice that was given of the meeting, Your Honor, was at the March 10th proceeding. It was announced by the board chair that there would be a site visit. There was no publication in the newspaper.
If someone, just an interested member of the public, wanted to show up, was there anyone to stop them from attending?
They were stopped, Your Honor. As I indicated, there was an abutting property owner who attempted to participate, and the board chair spoke to him and asked him to leave. It was a very pleasant conversation, but he had to leave.
Counsel, let me just, correct me if I'm wrong, but at the March 10th, at the conclusion of the March 10th hearing, the record was closed
Yes, Your Honor.
and there was no provision for supplemental testimony or supplemental information to be submitted.
That is correct, Your Honor, and nor was the record ever opened again.
So the record was closed and this site visit occurred subsequently, at which there was apparently essentially further evidence or further information given to the board. Correct?
Yes, Your Honor.
Okay.
Precisely. Information, argument, and the various statutes and ordinances and the rules of the Board of Appeals that we have produced in the record indicate specifically that there are to be no closed meetings. That is statutory. And one of the, I believe it's in their own rules, it indicates that if they have a closed meeting, the applicant will not be in attendance, and no evidence and no argument will be taken during that closed meeting. At the risk of missing something here because my time is running short, I would like to indicate to the court that amongst all of these other procedural problems and due process issues, we do feel that the process for the special exception was done completely incorrectly as a matter of law. And more specifically, I will state that the exception that was granted here was for a research facility without the processing of materials. Your Honor, I see my time is...
You have one more minute before.
Yes, sir. Without the processing of materials. There are two classifications within the table of permissible uses, and the other one is a research facility with the processing of materials. This facility calls for a weapons firing range, an assault weapons firing range, the size of 3 football fields. It calls for a driving tactics range 5 acres in size. Simply put, the table of permissible uses also requires that you select the category, the classification that most closely fits the uses that are proposed. Certainly, the use proposed here is not appropriate to say a research facility without the processing of materials. This should, at the very least, been a research facility with the processing materials. The reason it wasn't is because it doesn't fit into that zone. They couldn't have used it in the AC zone. Thank you for your attention.
Yeah, so you'll have 5 minutes on rebuttal.